Justice Street, yeah. Thank you very much. Let's go ahead and get the meeting started. We're together here to do the Texas Department of Licensing and Regulation Orthotists and Prosthetists Advisory Board meeting. And we'll go ahead and get started. It's 10:05. No. Yes, 10:05. 10:05. I didn't look at my watch. First thing is going to be the call to order. Next is going to be do the roll call. So Miguel Mojica, I'm here. Kevin Matthews.
Here.
Sterling Phillips is absent. Randall.
Present.
Duncan. Catherine Mize.
Here.
David Aarons.
Here.
And then Catherine Piskowski is not here. So thank you very much. All right. Next on the agenda is the approval of the minutes. I'm sure all of us have reviewed the minutes and we're good. You did?
Motion to approve.
We have a motion to approve.
Second.
And we have a second. All in favor?
Aye.
All against? So moved. Next on the agenda is the public comment. Did we have anybody sign up for public comment? Oh, okay. So no one is here for public comment, so we'll move on to the next item on the agenda. And we are now on item E for the staff reports. Licensing Division. Thanks.
Good morning, Advisory Board members. Leonard Rivas, the Licensing Division. In your packets, I provided you with the licensing statistics for the fourth quarter for fiscal year 2017, the total numbers for fiscal year 2017, and the first quarter for fiscal year 2018. I'll go over the numbers with you. For licensed prosthetists, orthotists, for first quarter fiscal year 2018, we issued 1 new license, 28 renewals, and the total population for that license type is 238. Licensed prosthetists, 1 new license, 8 renewals, and 91 is the total population. Licensed orthotists for fiscal year 2018, first quarter, 2 new licenses, 7 renewals. The total population is 119. Registered prosthetist, orthotist student, 1 new license, total population 62. Registered prosthetist student, we have not issued any new licenses for the first quarter for FY 2018. The total population is 14. Registered orthotist student, no new licenses. The total population for that is 13. And for the temporary licenses for the first quarter for FY 2018, we issued no new licenses, no renewals, and you can see the population is 0 for all 3. Registered prosthetist, orthotist technician, we issued no new licenses, no renewals, and the population is 8. Registered prosthetist technician, no new license, no renewals, total population is 5. Registered orthotist technician, no new license, no renewals, and the total population is 2. Licensed prosthetist, orthotist assistant, no new licenses, no renewals, total population 22. Licensed prosthetist assistant, no new license, no renewals, and total population is 9. We're almost done. Licensed orthotist assistant, no new licenses, 1 renewal, 25 is total population. Accredited prosthetist orthotist facilities, we issued 1 new license, 26 renewals, and the total population is 219. Accredited prosthetist facilities, 1 new license, 4 renewals, 27 total population. Accredited orthotist facility, 3 new licenses, no renewals, and 23 is the population. Do you have any questions about the licensing report?
I have, go ahead.
Go ahead.
Kevin Matthews, these numbers just seem awful low for the total fiscal year. Is that the total number of, I
That's the
guess
to-
that's just that were renewed in that year?
This is for the first quarter of fiscal year 2018 is what I went over. Are you asking about the total FY 2017?
I thought there was more of us than that.
The population?
The total population, I'm not.
Well, these are populations based on license type. Right.
There's only 93 licensed prosthetists
Right.
in the state?
Correct.
Oh, okay. Thought it was more than that.
So I don't know if this is Catherine Mize. I don't know if this is the correct place to ask this, but I'm still sort of haunted by our unique qualifications. And when you get a questionable, somebody trying to license under UQ that just has a really weird sort of resume, are you all still reaching to designated professionals to help you understand their
So with
resume?
UQ, as I stated in previous meetings, The UQ applications, we run those through Yvonne in compliance. So she takes a second look at those uniquely qualified applications. And if she sees something questionable, we'll reach out and ask for additional information. And then once we receive the additional information, we run it through Yvonne again. So she's our second set of eyes for the uniquely qualified applicants.
Okay. Okay, thank you.
Okay.
So Kevin Matthews, would it
Yes,
be
sir.
possible, because there are discrepancies and views on unique qualifications, that it could come before us for a recommendation, or is that not possible?
I don't believe that that's the way TDLR's processes are. We don't bring typically applications.
Mary Winston, TDLR, that Mr. Matthews is not the process. If we did need some sort of further expert opinion, then we know we can reach out to you guys. But actually, how many UQ or uniquely qualified applications have come through? I know it's
I would
not a
have to
lot.
run the numbers, Marion, and get back to you.
And I'll.
There's
I'll-
not that many.
Yeah. I had a number, but that was some months ago.
Yeah.
So we can get that number for you, but it's very low, and it's not been the volume of work that has overwhelmed Yvonne at all.
Right.
Or that we've needed to reach out further.
This is Miguel Mojica. We did.
We had a work
We
group.
did look at a few.
Right.
That had come through, and I felt completely comfortable with what the decisions that had been made. Yvonne did reach out to me on at least one of them, and I took a peek at things. So, in general, it seems like the numbers are down. I'm not too sure if the word got out. We're going to be sticklers about what is kind of what we've decided. I don't know what the deal is, but it seems to have calmed down. I don't know if Yvonne maybe should comment on that, but anyway, but yeah, seems to be going well at this point.
We're in
I
good
agree.
hands with Yvonne, so,
Yes.
thank you.
Sure. I have some personnel updates. We added 3 new members to the medical and health professions group. Veronica Coronado started September 1st. She came to us from the podiatry board that transferred to DDLR on September 1st. Chara McCrane started with us November 1st. She comes to us from the Department of State Health Services. And Audrey Strawn started with us October 16th, and she comes from the Department of Motor Vehicles. I want to update you also on criminal history. We talked in previous advisory board meetings about running criminal history on all renewals for individuals. That has started. That started November. So every renewal that is submitted to us has a criminal background check. The other thing I want to talk to you about is we talked to Catherine prior to the meeting. I know some of you, the advisory board members, receive, complaints about our processes and that their application is stuck for some reason. I just wanted to reassure you that our overall processing time for initial applications is 7 days at 91%. That concludes my report. I'll be happy to answer any more questions.
Thank you very much.
All right, thank you.
Morning, board members.
Morning. Next is going to be customer service. Thank you very much.
My bad. Just jumped the gun there.
No, you're fine.
That's good customer service.
It is actually.
Proactive. My name is Trey Seals, and
Okay.
I'm the Director of Customer Service Division. And just wanted to let you know that we've been here all along. It's been a couple years now, I believe, at least a couple of years now that we've been in this relationship with the podiatry industry. Podiatry, that was, what day was that? I'm sorry. That, wrong one. Orthotists and Prosthetists. I've practiced this.
Very good. You did a good
So,
job.
thank you. And so,
How nervous y'all make everybody, Catherine?
I'm testing you, see if you're present and with me in the moment here. But anyway, the point is, we have been here all along behind the scenes, and it became clear with the addition of the new programs of the last couple of years that the Customer Service Division has a great story to tell. We do a lot of hard work for the agency and for the industries we serve. And we feel we are the heart of the agency. So It was decided at the beginning of the year that I would be included on the agenda for the upcoming advisory board meetings. So I'm making introductions to each board. And I also have one of my managers from customer service who is responsible for this industry. His name is Tuan Nguyen, and he may be presenting for customer service in the future at future advisory board meetings. So just a little bit about customer service. We are a team of 50 individuals, and we are a committed and hardworking, passionate for service group of people. We are problem solvers and innovators, and we have had a rise in the volume of work that we've received over the last couple of years, but we are up to the challenge. We, in the last year, had over 500,000 contacts, and so that includes phone calls, that includes emails. We have walk-in customers we serve at our headquarters downtown. We respond to social media posts on Facebook and Twitter. We do get questions through those channels as well. And so it's a busy operation with a lot of complexity and lots of opportunities for improvement and engagement with our customers. We currently offer services and have staff who speak a total of 5 languages and 6 starting next Thursday. So we have folks who speak, of course, English and Spanish and Vietnamese, Mandarin, Korean, and now Thai. And we have a really diverse licensee population. So those languages do get called upon for assistance. We started out, just for a little bit of history on customer service and myself, I started out with the agency in 2005 when I came over from the Cosmetology Commission, and that year was a big year for the agency, and it was significant growth all at once with over 250,000 licensees. And it's been an awesome ride with the agency for the last 13 years. We had a 9 to 13. It shifted right when the work came over, and some people decided this wasn't for them anymore, and that was too much work. But we had about 13 agents. We were on the first floor, and it's just been an amazing process to watch the agency continue to take on new industries and to learn about new programs and to things that I just didn't even understand or know that the state of Texas was involved in, and the agency is now participating in serving our citizens and our licensees. To talk about statistics, just a quick highlight for the from September for this fiscal year, there are approximately 100, a little more than that, phone calls and emails, and they tend to be evenly distributed for this particular program. So as you can see, the volume is not that high for this particular industry, but it is a more complex, as you were speaking with previous presenter Leonard from the licensing division, it is a more complex program for us. We are charged with the initial contact and the entry or introductory or the basic things that you would find on the website, questions about an application, just quick little things to help get people down the road to completing whatever their objective is, to either get an answer or response from us or a license from us or determination from us. And so our work is really connecting the dots for folks and making the path more clear and that journey easier and getting folks to the right place. So Yvonne is someone we would rely on heavily as needed and quickly get those folks who do contact us over to the right person so they can get the answers that they need to complete whatever process they're working on. That concludes my introduction. I'm happy to answer any questions if you have them.
Catherine Mize, do you all have the ability, and maybe you don't, but do you all have the ability to track your most frequently asked questions?
We do.
Or you do?
We do.
Have you all been able to identify anything that maybe could be included on our webpage up front that you all repeatedly get asked over and over and over?
Glad you brought that
Yeah.
up. That is one of the things that we do as another function for the agency is we do contact and know a lot of firsthand experiences the customers are having. We do get that information over to our Office of Strategic Communications and our web team to update content on the website. We also give feedback to our licensing division. You know, we keep having this question on this particular spot on the form. Could we maybe work together to come up with, you know, a tweak to the language that may help customers, or we'll reach out to our IT division with questions or requests for updating to certain instructions on the website for various processes. So that is something we do track. And for this particular industry, it is mainly not major questions for us. They do pretty much stick to the high-level application type quick questions. And if we don't, like I said, we do rely heavily for this program on licensing and compliance, as we don't get really deep into the details on this program. So.
Well, if our applications were pictorial in nature instead of words, they'd
I
be a
agree.
whole lot better for us, because that's how we
We're
work.
all different learners, styles, and we try to absolutely visual. I'm a visual person as well, so I appreciate maps with steps. I agree. That's something we've talked about as well.
Mary Winston, TDLR, and also Catherine, our Chief of Staff, who is busy working, and I'm going to just toot his horn a little bit. He holds, with the team, a weekly meeting to catch up on just this sort of thing.
Yep.
With customer service, the staff of OSC, which includes our web team, our social media team, who am I forgetting?
Intergovernmental relations.
Intergovernmental relations, public information. And so this kind of question is brought, Trey's there, some of Trey's managers are there.
Yep.
Questions are brought up there. This is what this is looking like, you know. Where do we need to tighten up here or there? So it's a collaborative effort, and that's weekly, because we have a lot of responsibilities, a lot of licensees, a lot of little things that come up before anyone else will even notice that we try to take care of. So we really do try to keep a good handle on that.
Yeah.
Well, I was at one of our national meetings, and I got stopped by several people that said the customer service has been so much better than it used to be, and they've been extremely happy.
Thank you for that
So
feedback.
there's
Thank
a few outliers here or there, but I think if those outliers had pictures, they would be better off. So, but from
Thank you.
the by and far, I've gotten really great feedback.
Thank you. Thank you.
Thank
Oh,
you very much,
that's
Mr. Steele. That's it.
Thank you.
I'm glad you said you were new, because I didn't recognize you, and then even on the list, I'm like, oh my gosh, have I been sleeping on this one? So thank you.
Thank you.
And I'm glad you're joining the meeting for a report. Next is going to be Field Operations Division.
Good morning.
Good morning.
I am Tanya Guthrie. I'm the Director of Field Operations. And for our report today, we're going to start out with our most common violations that we found during the inspections that we performed in the first quarter of this fiscal year. One thing I just wanted to point out is that most of these violations that were cited, but they could be corrected. The last one, though, listed as number 5, is a direct enforcement violation if somebody's operating with an expired license. And that would mean that the inspector would write a report, collect the evidence, and then forward that information on to our enforcement division. Okay. The next item I have is we've been able to hire 2 additional inspectors. They started in January, and they're both located in the DFW area. And then we have our statistics showing the number of inspections that we have been doing. I can let you know that so far in February, we've done an additional 8 inspections. But of course, that'll be reported the next time we meet. And that's really our report. Does anybody have any questions or?
Have they been going well? Are the inspectors treated well, I guess?
Oh, yes,
When they
no.
come in? Okay, there's no,
Well, no, especially
no up in
everyone's very
arms?
polite.
Are we misbehaving? Is that what you're saying? Is our
Yes.
profession misbehaving?
No. We have a lot of
Get
different
out.
kinds of programs, and no, everyone in this program has been very polite. We really appreciate it. It's going well, and, it is the kind of thing where we're fitting it in with all the other inspections that we do. But we've got 3 inspectors who know this program spread out throughout the state, and we're, dedicated to getting them all done as soon as we can.
Good.
Okay. Is that it? All right, thank you, guys.
Thank you very much. Next on the agenda is the Enforcement Division.
Good morning, Chairman Mojica, board members.
Good morning.
My name is Virginia Fields. I'm a prosecutor with the Enforcement Division, and I'm here to give you the enforcement staff report. You can look over the report that's in your package. I'd like to start with the recent accomplishments. With the transition of all the healthcare and the podiatry programs, we have started a medical and health-related team headed by 2 prosecutors, myself and my esteemed colleague Karen Cox, will be devoted primarily to these cases in the future. If I'm unavailable to come to an advisory board, my partner in crime, Karen Cox, will be here to present the report. If I can, I'll go over the case highlights and then take questions and go over key statistics. First case on September 25th, there was an agreed order entered with Eric Odling. This was an inspection and a result of the audit of the documents through the inspection. There was a $500 penalty assessed for holding yourself out. The inspection occurred on May 25th, and the dual license for the facility, orthotic prosthetic facility, was issued on November 30th of 2017. The second case was entered on November 14, 2017. This was a default order entered against Victoria Orthotic and Prosthetic Services. This was for negligence in failing to perform or providing products for which compensation was received, but failing to exercise reasonable care in the delivery of orthotic shoes. This resulted, it was a default, and because of that, it was for the full penalty amount sought, and that was $3,000. The final case was entered as an agreed order on November 28th, 2017. Bill Messer, this was a 1-year probated suspension of his orthotic prosthetic license, as well as a $7,000 administrative penalty. Unfortunately, after the order was entered, the bank was a little delayed in letting us know, but the check was dishonored at this point, and we have begun proceedings to revoke that license for failing to comply with this order. So at the next meeting, we should have an update on that. If there aren't any questions on the cases, I can move forward with the key statistics.
No questions.
All right, I'll wait till the next meeting.
Oh,
Your key statistics give both the 2017 numbers and the 2018 numbers. The 2017 were essentially presented at your last meeting in July, but there was one order that transferred over from the prior agency. This was an agreed order and $5,000. Essentially, the agreement had been reached at the prior agency. We just went through and carried out with the entry of the order. For 2018, currently, there are 8 cases open. You can tell that transferred over from 2017. The number of cases resolved at the time this report was completed were 7, with the 2 agreed orders I just discussed. Collections are probably not the best for the department. Again, this was partially due to the default that was $3,000, which is in collections. A lot of times what happens, as I understand it, is Victoria has gone out of business. So this will probably go over to the Attorney General's office for further collections, typically an abstracted judgment filing. But that's all I have for my presentation. I'm more than happy to answer any questions you have.
no questions.
All right, thank you.
Very much, Virginia.
Appreciate it.
Next on the agenda is going to be Education and Examination Division.
Good morning, Mr. Chairman and board members.
Good morning.
I'm Jerry Gonzalez with the Education and Examination Division. My report is fairly short. Our division acquired or welcomed 3 new members to our team, Jennifer Prince, Amy Henshaw, and Angela Schmidt. We also, as noted in your report, have 10 individuals that have completed the jurisprudence exam, and this is from September through the end of January. Other than that, our team is working hard with legislation that passed and the new programs that have come in, and just working to continue with a smooth transition as best as possible. I'd be happy to answer any questions you may have for me.
I have one. It's not
Catherine
a question.
has one.
It's a comment, Catherine Mize. And maybe this is silly on my part, but I've gotten several inquiries about how to find the JP exam on the website.
It's on the web page under the examination.
It
and
is.
see-
I
'cause
found it, but it was kind of an embedded pathway for somebody that doesn't know the web page.
Okay.
And I was just wondering if there was any way you could get with the web team and make it a little bit more user-friendly to find?
Jerry,
Certainly.
I can step in for a second. Nick Voinis, TDLR. We are working on that.
Okay.
We're doing it program by program, and we've
Perfect.
gotten a good jump on it, so we're working on that right now.
Yeah, well, I could find it, and I'm not
We
very
understand.
good, so that's great, but it
No, you've raised a
took a
great
little
point.
bit of work.
Yes.
Yeah, okay,
It's something that needs to improve. Thank you.
thank you.
Anything else?
All right, thank you. Have a great day.
Appreciate it, Jerry.
Thank you.
Next on the agenda is the Compliance Division.
Hi, I'm Yvonne Feinleib with the Compliance Division, and you have our report in your packet. It talks about the Standard of Care Work Group, which has made recommendations that are included in the proposed rules you'll be talking about later. We've also produced an updated checklist for the unique qualification applications for licensing to use, because there are so many little nuances to those applications that our licensing staff asked for some more guidance. And we're continuing to work on updating checklists for them to help them, because when a person applies, it's sometimes hard to see what flavor of unique qualifications they're going to be. If they're a regular applicant, you can see their degree and you can see their NCOPE residency and all that, you know, they're not complicated. But UQ, because we have to look on a case-by-case basis, what they might ask for and what they might need to see can be a little complicated. And I usually look at all of those before they get licensed. And some of them have already been licensed, and there are people waiting to pass the ABC written before they get licensed also. We don't have any meetings on our schedule right now, but I assume that we will. And then we have an update on the medical and health professions section. So we're still working on making sure things are going smoothly with Phase 1, but we've also been working with our Phase 2 programs that came over on November 1st. And those are more programs from the Department of State Health Services. And so there are various things involved with helping them get settled here at TDLR and get up and running smoothly. And so we've been working with them as well. Do you have any questions?
I do not.
Are you sure, Catherine?
I'm sure.
Catherine has no questions. Anybody else? No? We're good.
Thank
Thanks,
you.
Yvonne. Appreciate it. Next on the agenda is a report from the Executive Office.
Mr. Chairman, board members, Nick Voinis, TDLR Chief of Staff, here to give you our Executive Office report, kind of a summary of what's going on around the agency today. I want to thank you for being here, and thank you for your service to the state of Texas. TDLR staff's been pretty busy the last few months implementing legislation that was passed over the last 2 sessions of the Texas legislature. So the process continues as we develop and review rules. We communicate to stakeholders, appoint and prep advisory boards, hire additional staff, and deal with education exams, IT programs, and more. Majority of the work has been completed, but this is a process that'll continue as we implement programs this year and next year. This spring, we will take on our strategic planning exercise to improve the way we regulate our programs. It's something that the legislature mandates state agencies do every 2 years, and it's something that we take very, very seriously. 2 years ago, for example, we identified 58 strategic initiatives to address during last year's session, and proud to tell you that 56 of the 58 were passed and signed into law. We'll be going through this important process again here very, very soon, and you'll be hearing more about that as we get closer. Want to take a couple minutes to update you on your website. TDLR.texas.gov is our chief tool to communicate with stakeholders and the public. And I wanted to share with you some recent web traffic numbers associated with this program. Over the past 6 months, your site has had 6,084 page views. That's an average of 66 per day. You may be wondering how people are accessing the site. 80% of those visitors accessed your site from a desktop, while 16% did so from a smartphone and 4% from a tablet. The top 5 reasons for visiting the site are, number 1, laws and rules, followed by forums, frequently asked questions, continuing education, and exam information. Want to mention also this does not include online licensing. And as I mentioned earlier, we are in the process now of a program-by-program content initiative to kind of make things a little more user-friendly. We're always looking to that to help our licensees get to where they need faster and easier. Also wanted to, in addition to our web presence, to remind you of our social media accounts. We have a presence on Facebook and Twitter, so please feel free to check it out to keep up with TDLR news and activities. We also have more than 4,000 subscribers who receive our various email blasts pertaining to your program. And if you're not receiving those notices, you can go to tdlr.texas.gov and subscribe. Also wanted to mention something that, like most organizations, we tend to focus on external communications, but we are very, very involved internally in improving our communications. And I know Trey Seals has been real active with us. We, thanks to Trey, we're doing a weekly update to all directors on different topics and issues that people are calling in about to try to help us internally. And it's due to the rapid growth that we've had over the last 2 or 3 years. Finally, wanted to mention, our staff's known for its generosity, and this was confirmed again earlier this month at the State Employee Charitable Campaign Awards Ceremony, where TDLR was awarded the highest per capita gift for an agency of 301 to 500 employees. So this means our staff contributed more per person to the 2017 campaign than any other agency in our size group, and it was more than $34,000. We're real proud of that. Thank you.
Great.
Be glad to answer any questions. And I will add one thing, excuse me for not mentioning it earlier, but since your last meeting, the agency suffered a real tough loss. One of our directors, George Ferry, passed away. He was director of our compliance division, and he died in late October 31st, and we miss him. He was a great leader, a great friend, a great man, and just want to pass that along. We also have a seat back here reserved in his honor.
Any questions? Catherine? No. We're late. Thank you very much. Next on the agenda, we're on item F. So discussion and possible recommendation regarding proposed changes to the rules under 16 Texas Administrative Code.
You have the changes in a sort of a condensed form, just showing the changes that are being proposed, and you also have the current full rules. But at the last meeting, we went through a lot of these changes. They don't show, of course, in the current rules yet because they're not proposed or adopted yet. So your rule document is just, the way it is now, and the changes you're looking at today are ones that mostly you saw already at the last meeting, but in addition to those are some additional tweaks. Since your last full meeting, the work group met and worked on some of the things that were discussed at the last board meeting. So there are further changes, there are further cleanup changes, and so as we walk through, I'll just kind of point out what's new and what's old and what's modified. These rules need to be, to keep on track, you need to, make a decision to vote to propose or not to propose today. So that's kind of the objective today, is to get agreement to propose them. You can make tweaks still in them. We just need to settle on final language for proposal. And I have the set of rules as they looked at the last meeting, in case we need to look back at what it said then as opposed to what it says now, which of course is different from what the current rules are. But to avoid confusion, I'll just kind of go through the changes and we'll just walk through. And there are basically two kind of changes here, which we talked about last time. Some are from the HB 4007 that passed and made some changes to the statute, and so therefore there are some rule changes associated with the statute changes. Some of the statutory changes didn't have a corresponding rule that needed to be changed, so not every statute change resulted in the need for a rule change. And so the first change is in the definitions, takes out the Texas resident definition because the residency requirement was taken out of the statute, and so therefore it's taken out of all the rules. You saw that removal of that definition last time. And the very next change would be just a citation correction. In the application section.
Are you on the draft changes?
Yeah, you should have,
She's on the first page.
Okay, right there, sorry.
She's
Yeah,
on 114.20
Yeah,
applications.
okay, thank you.
Yeah.
Sorry.
I'm looking at the full version of the rule with the changes so I can kind of give you context if we need it. Because you don't really get it in this list of just the changes. A few places we cleaned up some language. Sometimes you'll see a change in what we're referring to, the act or this chapter, because that's the statute of the rules. It's not really anything controversial, just what authority we're referring to. And statutory or rule citations that needed to be corrected. As we updated the rules, some things moved, and so therefore you might see a citation correction. And that you'll see that in the application section, so there's really nothing controversial there. In the uniquely qualified section, we removed the reference to the resident of Texas and just put person there. In the temporary license section, you've seen this before. This is just to update to match what the statute is saying. Most of the time, we don't repeat the statute, but here, this section was already there, and we decided to leave it and just match it up. This is really sort of a reciprocity statute, you might say, and rule, because it deals with people coming in from out of state, but since there is no residency requirement, it's compliance's opinion that there really are not going to be very many temporary licenses applied for. But you saw those changes already. Student registration, this you looked at last time. The main thing that changed in student registration is that it was expanded slightly to cover the time after they complete the residency until they pass the exam and get licensed, so that they need to be and can be working under the student registration. And we've kind of made a sort of a decision to go with using the word work instead of practice for a student, since they are not licensed. And so you'll see that they can work under supervision. You won't see them practicing. So that word was changed in the under clinical residency for an assistant under B. We changed that from practice to work to be consistent with the other places where we're saying they can work under supervision. And in scope of practice, the days for the sign-off on the clinical notes written by the assistant was changed from 10 to 15, again, for consistency with the national standard. Just some grammar, word choice changes for assistants may practice only in a facility accredited. The registered technician, we took out registered and just make the prohibition against providing patient care applicable to all technicians. We talked about that last time, and that was always true, but the rule wording matches up better with reality that they can provide patient care, whether they're registered or not. The next section is really where there are a lot of changes and some that you didn't necessarily see. Some of this is just reorganization and rewording. It really is not changing in the very first section there that has all these changes in B, the accreditation requirement. It's restating and kind of clarifying when it's applicable and when it isn't.
Excuse me, sorry.
Uh-huh.
Where are we?
We're in the accreditation of facilities, section 11429.
Okay, so we're not going over each one of these? We're just running through it? Because I've got a question on assistant license.
Oh, okay. Yeah, well, like I said, some of these you've already talked about in the last time, so, we can talk about it again.
Some things weren't resolved last time either.
Yeah, and some of these were worked on in the work group because, they were debated at the last meeting, and then in the work group, they were addressed again, and there may or may not be a change according to that. So which one did you?
So it says that an assistant must practice in a facility that's accredited or where their accredited requirement does not apply.
Mm-hmm.
So does that mean an assistant can work for a doctor and practice as an orthotist or prosthetist under a doctor? Because doctors aren't required to have accreditation. It sounds to me like if the accreditation requirement does not apply,
Mm-hmm.
then
It does in the act.
This is about facilities.
Yvonne, hey.
so they have to practice under a licensed person. So then that answers my question. You just told me.
I think Yvonne
just-
had, did you have some comments? I'm sorry, Mr. Matthews. But we just want to make sure, because we can hear her in the room, but when she answers from the back, it doesn't pick it up for you too.
This is Yvonne Feinleib. So this is about the facility requirement. So if an orthotist or prosthetist is practicing in a location like a hospital that doesn't require the facility accreditation, they can use their assistant. This doesn't authorize anybody else to supervise an assistant. That's controlled by the statute. Does that
Thank you.
make sense?
Yep.
Okay, so the, under accreditation of facilities, this is really just kind of making it more clear which ones the accreditation requirement doesn't apply to. It isn't changing anything, it's updating the little list here of the types of facilities to include the most common ones. And number 2, it says any facility that doesn't hold itself out as performing or offering to perform O&P, and at which persons providing healthcare services do not perform or hold themselves out as performing O&P. I included this as an and because if either one is holding themselves out, then they wouldn't be exempt from accreditation. So that was just, it's kind of restating, but it's making it more clear that neither the facility or the practitioners can be holding themselves out as practicing without the accreditation requirement kicking in. And let's see. The rest of the changes here are just cleanup. In the, let's see, section E, general requirements for accredited facilities. I want to cover a few things there.
At the bottom of page 4, E.
Yeah, and if you're looking just at that
Yeah.
document, you're not seeing where they're fitting in the whole rule, but the general requirements in this section for facilities is covering the posting of the accreditation certificate of both the facility and the practitioners. So in E3, it says an accredited facility must display the accreditation certificate in a prominent location in the facility where it is available for inspection by the public. And then in number 8, an accredited facility must display the license certificates of the practitioners in a prominent location in the facility where they are available for inspection by the public. At the last meeting, that public word there had been changed to available for inspection by the patients, but this is not being changed to say the patients. It's going to continue to say the public, and that means that the certificates need to be basically posted where they currently are required to be, where the public can see them, which means they're like in the lobby, reception area, front area where a person walking in can see them. I know the discussion addressed, being able to at least post the practitioner certificates where just the patients could see them, so that you wouldn't have this massive amount of certificates right in the front lobby. And Field Ops was okay with inspecting for that, but during executive review, it was decided to leave it open to requiring it to be available to the public. And so I wanted to let you know, because you won't see that change here, because that change is not being made, but it was something you discussed and looked at the last meeting. So I wanted to let you know. Okay. Well, and that, let's see, that's page 5.
Excuse me, I had a quick, Kevin Matthews, I had a question on where the page before, it says a person licensed under the Act, Texas Occupation Codes, it's crossed out, basically saying that practitioner must practice out of an accredited facility unless he's practicing somewhere where they're exempted. Is that like no longer part of the, why is that crossed out? So we don't need to practice in an accredited
No,
facility, or?
it's covered in, that was the old language, and it's covered in B now, up above. Let's see.
It's on page 11 now.
What does it say there? It doesn't say that.
Well, it does. Catherine? It's
I
on
think
page
because
11
this
now.
is just hodgepodge, I can't, I mean,
Yeah,
it would be better if we just had the act and then, so I could see this. Because according to if I were just looking at this, it looks like you don't have to practice in a licensed facility, and 1 and 2 does not say that practitioner needs to practice out of a licensed facility.
Mr. Matthews, everyone, Mary Winston again. We can get a copy for you for everyone of the whole thing, which would be easier to follow. So if you would like to, Mr. Mojica, call a break, we can give Tam some time to get some
We have
copies
it
made.
electronically right here.
Would it be better, is it okay electronically? or-
Yeah, how do you find it?
It's right here. It's right here on number 11. That's what you-
Which one, what are you saying?
We moved it to page 11.
Okay.
There's where
Oh,
it is.
okay, yeah. I don't know why this still says patient two. Supposed to be approval occurs. Does that mean if it's-
It's over way above
Mr.
page
Mohican?
11, but
Yeah.
we're back here.
So
All
it
right.
just got moved.
Let me go ahead and take a break so we can get this organized and then get started again. So we're breaking at 11 o'clock? Yes, we're breaking now 10:58, and we'll get back at 11:15, okay? That's all.
All right, next meeting, next time we have one of these, send out an email. Okay.
The highlighter would be awesome. So,
So your first, when you think about what can assistant do, is it off the shelf? Yes.
All right, I'm going to go ahead and call the meeting back to order again. And it is 11:20.
yeah, I like it. Clear now.
Okay, I'm Laura Pefferly from the General Counsel's Office, and we're continuing with the rule discussion. You have a copy of the whole rule set with the changes highlighted, and so you can see them in context, what we've been going over. And again, many of these changes were in the draft you saw at the last board meeting, and so I'm sort of trying to point out any changes from what you've already seen. And some of those were recommended by you at the board meeting, and some came through the work group. And in the draft, we were on page, well, my page may not be your page, but 11429, accreditation of facilities. We were in that section. And the requirement for the practice setting, that's actually been moved to the brand new section, which is 11475, which is later on in the draft. There's an actual section for practice setting, and so those requirements are deleted from this part, and they're just moved back there. So we can look at that now, or we can look at it when we get to that section, but they are there. And the accreditation requirements, of course, remain here in this section for the facility, and who it doesn't apply to and who it does. So that's still there. That's reworded slightly, but there really isn't any change. There was no change in the statute as to who it applies to. It's just kind of cleaning up the rule to make it more clear. And then there are a few other scattered changes in that section, but they're really just kind of clean up, except when you get to number 10 under E, which says that an accredited facility needs to have the equipment, tools, and materials to provide these services. This came from the work group. To just sort of, to have that in there, it's kind of a no-brainer that they need to have these materials there, but this puts it into rule.
And this came out of previous language. So this is what we used to have. And we've moved it.
Yeah, we've cleaned up and sort of reorganized in the facility requirements, and so we're gonna talk about those. But anything you see in yellow that looks deleted, it may just be moved, and so it's likely still there. It's just been moved. We did delete the very last part in what was K is now J. that a telephone has to be available for patient use. We felt like that was outdated. You'll see the changes about the chairs with the armrests and the wheels. That was discussed at the last meeting, and that's, see that still there. The accessible restrooms, that language had been reworked, still there. The very last section is deleted, but those requirements are earlier in the section now, so that section could go.
So we're on page 17 now, and you'll see there was a section O, general, and that's what she's referring to that was deleted because the section on required equipment and the section on restrooms were moved.
And Mary Winston, could I have y'all speak up just a little bit? Do you need one more mic? We did have a request that we could not hear. People watching couldn't hear. Try to get one more microphone.
Okay.
I can be louder. I
Speak up,
believe
Dawn.
you.
Yvonne, you can be louder. You give me permission. Go ahead. Have at it.
And I was talking about the posting of the certificates for inspection by the public or by patients. The facility certificate that's going to remain where it's going to have to be posted for inspection by the public so that anyone walking in can see the facility certificate. I'm checking on the posting of the practitioner certificates to make sure, because I know it's still in your changes here, that changing it from viewing by the public to the patient. So I want to make sure before you vote on that, if we can clarify, to make sure that we are not changing that to viewing by the patients or the public. So that, hopefully by the end of the meeting, we clarify that to make sure on that one. And so, I think if you've looked at that section, if you have any questions about it, I know you've seen a lot of this and we've talked about it. If you have any additional things you want to talk about there.
I think we're good to move on to the next section,
Okay.
11430.
Okay, yeah, and that section has some changes that came from the work group. I don't believe there were any changes the last time you saw this, but a few things have been added in here because an issue or two came up with students who had lapsed registrations and completed residencies, and there was an issue about, well, because they didn't have a registration, did their work count, basically? And so what we decided, and through the work group, was to add some more responsibility on the residency program to make sure that they make sure that their students hold a current registration. They're supposed to, but this just adds a few requirements in there to make sure they're doing this. And so you'll see mainly in I think it's your page 18, it's number 10, where they have a list here that they have to give a written description of the program to the residents, and in that list is this requirement that they need to inform them of this requirement under the Act to hold the current student registration while they're in that residency. And then also, the program director has to ensure that they have the registration. This is in the next subsection there. And I puts an obligation on that director to make sure they are registered. And then at the very end of the section, in section J, we had added this where the resident, the student can continue to work under that student registration after the residency until they get licensed. That part, you've already seen that. So that, yeah.
So Yvonne Feinleib, so the language authorizing the student to continue to work under their student registration until they are ready to upgrade, they are already doing that. This is just to make it clear that that is not a problem. The language about the requirement for the residency director to ensure that the students hold a student registration came out of a problem with a non-NCOPE residency.
Question on residents, Kevin Matthews. So we're required to have all of this information, term of residency, job description, all of that. With Baylor's program, we're not the director of the residency. They are. So we don't have any of that in our own facilities. That's all comes out of Baylor. We don't have like an NCOPE residency director in my facility. They're at Baylor. So I don't have any of this. It's all directed out of Baylor.
So
So I think that at least the people that are looking for this should know, if they are looking, inspecting facilities and asking for this information, that would be something they would get from Baylor, correct?
If they were asking for it, I think this is more related to problems with people completing non-standard residencies and making sure that whoever is trying to run one is running it correctly, not with facility inspection.
Okay. Thank you.
If they're the residency program director, if that's where they're located, then this is, an obligation for them.
Correct.
It's their responsibility. Like at the very end of the section, we added that the residency program director can't sign off unless the student was registered during the residency. If they're the ones signing off, it is their responsibility, that, that person who has to sign off. So it mainly tightens it up to, require that, that's what, this is where they sign off. So, all the changes to that section are expanding the student registration so that they can work beyond the residency for that short period of time, and then these requirements to make sure they're registered. The next section is renewal, and that should be around page 21 of your long draft, and it starts on the bottom of 7 of the changes draft. The requirement for the department to send renewal notices is being removed from wherever it appears, and that it's being removed in the renewal section. That is not due to a statutory change. That is due to make it consistent with all the other programs, which basically do send renewal notices, but this is just removing this obligation that we have to send renewal notices, because, as the next section says, the licensee is responsible for renewing before it expires, but it's their obligation, so this is basically taking it off of the department to have this obligation to send a renewal notice. If they don't happen to get one, it's, they still need to renew and keep on top of that. So you'll see that's removed.
Can I say something
Sure.
else? So Yvonne Feinleib, so we don't send out renewal forms anymore. What we send is we send an email at 60 days and another email at 45 days and a postcard at 30 days and another email at 15 days. And so this doesn't reflect the department's practice. It doesn't mean we're not constantly attempting to get people to renew.
Repeat what you just said, email at 60?
60, 45, and 15, and then a postcard at 30. And this is, of course, only the people who still haven't renewed. So that number of things sent drops off as people complete renewal. We don't keep sending them a request to renew. That would confuse them.
How far out can you send in your renewal?
Right now, it's 60 days. Right now, if you mail it to us earlier, we haven't billed you yet. We haven't set you up in the system to process the payment.
These rules were, we tried not to change a whole lot when they came from DSHS. I mean, these are new rules, they're not DSHS rules, but we try not to change a lot of things. Some of the things that we didn't change that really needed to be were some of the terminology. And you'll see in here, we changed it from sending their renewal documents to a renewal notice, because like Yvonne said, we used to send them the form and everything, and we don't send them all that anymore, so we just change it to a notice. So they may get an email notice instead of a whole packet in the mail.
So, Yvonne Twilight, so when they get the postcard, it has instructions that if you need a paper renewal form, to return that postcard back to us, and we will print a one-off renewal form out of the database and mail it to you that has all your information, and you can sign it and return it. So that paper is still available, but you get the notice that you have to request it on the postcard.
It's very nice. Some nice spoon feeding. I like that.
Just needs pictures.
Exactly. Going above and beyond, I think.
The next changes basically are in the advisory board rule sections. A lot of those are just changing the headings to make it more clear that that section is referring to the advisory board, because we don't have subchapters that say advisory board rules or anything like that, so the heading is going to say that. And then it also makes the change from the statute change, instead of electing the presiding officer, that the commission appoints the presiding officer. You saw that before. That's from statute. So I don't think there's anything too controversial in the advisory board section. So then we are on to the brand-new section, and this is 11475, scope and conditions of practice. The requirements here are ones you saw at the last meeting. They've been reorganized a little, and a little bit has been added there. There was a lot of discussion in the work group meeting about these. Some of the things that were brought up in the board discussion were addressed, and some couldn't be. But if you're reading through, you'll see a new section in A under 2. There's an A and a B now. We just kind of split that out and then added the B, that a patient could request a consult, as well as an order or request by a person in the healthcare team, which would allow the patient to actually ask to have someone come in to see them. A lot of this section is getting at preventing solicitation, and so it's a sensitive issue about the patient's ability to have someone come in, or being bombarded by people coming in that they don't want or didn't ask for. So you'll see also in C, which this language is in there before, about the practitioners can't provide a consultation in violation of the chapter, or that's prohibited by the Occupations Code, section 102001. That's the anti-solicitation provision in the Occupations Code. It applies to the practitioner and also the person who's running that practice, that they have this obligation to help avoid this solicitation of patients.
Excuse me. So would that apply to marketers? It says practitioners.
The problem is that we don't regulate anyone except, you know, people who are practicing in the orthotics and prosthetics program. So we can't regulate the universe, basically. We can only regulate who we can regulate. And so this is prohibiting practitioners and facilities from engaging in these practices, but it's an overreach for us to prohibit anyone from coming in to solicit. But if they are affiliated with a practice, then they would, you know, we can regulate them. But, you know, our scope is limited as to who we can bar from doing this. But if,
So I'm sorry, just to clarify, Catherine Mize, in D, underneath, that's where we are attempting to reach the marketers that work for a practice.
right, they're like acting as an agent of a practice.
Acting as an agent,
And
so
that's about as far
they
as
could
you
be,
can go.
the way I remember discussing this is that they could be an employee of a practice, or they could be working on contract for a practice, trying to go out and solicit patients for them. And so if they're in any way associated with that practice, they can't do that.
I filed a complaint, and the complaint was basically denied, saying they don't have jurisdiction over marketers, while what the marketer did was in direct violation of what Medicare allows. The state doesn't have anything like that. This was a marketer hanging out at a dialysis center that approached a patient of ours. So is that now considered illegal
Well, it's
under the
gonna,
law?
it would depend on the association of that person, how they're
They
associated
work
with that facility.
directly for that
Yeah.
company.
Yeah, so, yeah, if you,
That company's now out of business. Medicare ran them out of business. But
yeah, and
that
this'll.
marketer now owns a practice.
Right.
But it's no big deal. I was just curious because they just threw it out saying, it's fine in Texas. You can catch patients at a dialysis center and try to sell a prosthesis from the door to their car.
So this would attempt to stop that, correct?
Yeah, I mean, as it went through the enforcement process, that those things, you know,
Well,
would
that
be
marketer
addressed.
hands her a card saying, I'm with prosthetics, whatever. We could file a complaint saying this marketer approached a patient of ours, and that would be something that would be investigated.
Well, I can't speak for enforcement, but they would look at this, and then they would attempt to determine if that person
Okay.
is working for that practitioner or that facility, and what the relationship is, the nature of that relationship. And then, you know, yeah, if it's something they can prosecute, that, chances are that would be going forward. There is also the occupations code that prohibits solicitation, so that's another source of law that could be applied as well, if that applies. You know, it depends on how that's worded and how that relationship is. So I would say go ahead and make the complaint, and then, you know, we can, you know, it's new, so we'll be working it out, and
And we can, Yvonne Feinleib, we can regulate consultation. We can regulate practice. We can't regulate advertising. If that makes sense.
Okay?
you know,
So,
yeah,
if you
advertising.
So
File
then
the
then a
complaint.
marketer wouldn't be, then that would be fine, in what you're saying.
It
Because
would
it's not a
depend on-
consultation, it's just me saying, hey, I see you're missing a leg. We make legs. That's okay.
Free speech, right?
Okay?
But if they started having a conversation about what their needs are, what was, you know, actually starting to discuss what is needed, providing an actual, any kind of actual care, then we
Well,
can
but that would,
regulate.
Randy Duncan, that'd be covered under the solicitation, which is in occupations code.
Yeah, and this also, you know.
Sounds like it's not.
Yeah, I mean, there's going to be a fine line between what's advertising and what's soliciting, and that's, it's going to be dependent on the facts of the situation, you know. I'm not saying we can guarantee that every time what you think is solicitation can be prosecuted. It's going to depend on looking at the law and the facts and determining whether, you know, we can do it in that case. But now, you have more in the rule now than you had before, for
Yes.
sure. So. I think for the most part, here, there's some reorganization, and that's this part under the consultation has been added, but I don't think there's anything too new here that you didn't already see, and we talked about a lot of this.
Well, one good thing in here I agree with is that we can do an initial evaluation and casting without having the prescription. We can just do no diagnostic fitting or fitting until we receive that prescription, which is very good in my opinion. That's a change that, nice. I like it.
Yeah, the rules are making more specific what you can do as opposed to just saying all the things you can't.
Right.
And, we can continue to work on putting more of this into rule so that people know, what is okay and what isn't. I think it's a good thing, so,
Yeah, less guesswork.
yeah. So unless you have any more questions on that new section, and of course, we have an opportunity to further tweak any of this because it's going out for public comment. And, comments may bring up something nobody thought about. And so, we can possibly make adjustments. We can't change a whole lot between, proposal and adoption, but there may be some things we can do. So there's another chance yet to before these are adopted, to look at these things. The next changes are in the fee section. This is really just clean up at the very end, it said all fees are non-refundable, so that's been moved up to A. This is really to be consistent with the way the other fee sections and other programs are written. Nothing really
I've
new
got
here.
another question, sorry.
Mhm.
Kevin Matthews, going back, I see it says persons licensed or registered under this title may provide orthotic or prosthetic care to an established patient of an accredited facility in the patient's private residence. So if I get a call from a physical therapist saying this child is homebound, can you come to the patient's residence and see them? And I really try to avoid doing that. I will on occasion. This says I can't if it's a new patient. Is that correct? What do you mean by established patient? Is established meaning I have a prescription for that patient and I've never seen them before? Or is it a patient that I've seen before?
Well, and that came from the work group, and I think you're correct. The intent was to avoid going to see new patients in their just starting a practice where you just go do home visits. This is an established patient, and the second part, number 3 there, says it authorizes off-site practice commensurate with the medical and physical limitations. So it's geared to a patient that's already established, that you can then see them in their home if they can't come in. But it's...
So by established, do you mean that we have a prescription for that patient? Is that sufficient to define established patient?
The goal was to make sure that people are working out of a facility. When we go in and inspect, we can see the records of all the care that they're providing, not that they've got a bunch of separate, private, in-home clients where the records are kept somewhere off-site in their home or van, and nobody can go see them, and nobody
Right.
knows what they're doing. So they're working out of a facility, even if they're seeing someone at home. So for your facility, it might be enough to establish that patient to obtain the order and make the appointment commensurate with that order and go out and see that and establish your relationship that way.
Thank you.
Does that make sense?
Sure.
And anytime I say anything that doesn't make sense, since I am not myself licensed, please say something.
Well, absolutely, we will.
Well, and I'm as well taking your lead. If you feel like established patient isn't clear, I felt like that was clear, that you all understand what that is, but
It's not clear to me.
maybe not.
To me,
So
an
you think that-
established patient is a patient that I've provided a service for in the past. In other words, this child came into my office and I saw them for AFOs, and now they're recovering from something, and they ask, can you please come see the child? We don't want to transport them because of whatever. Sure. So for me, an established patient is a patient that I've had a working relationship with in the past. So to me, I mean, I'd hate to tell that therapist, nope, I've never seen this patient before, I can't go to their home because they have to come see me. So a lot of people that are really by the book would look at this and say, I can't see any new patients out of their home, when in prosthetic situations, not so much my company, but many prosthetic companies work out of the patient's home. And they just, because we have patients in Lytle, in Sutherland Springs, and scattered around, prosthetics is so profitable, you have no problem going to the patient's home to do the work. In orthotics, you go broke doing that. But in prosthetics, and there's many companies where the patient never sets foot in that facility. And that's many, many cases. I would say more than 10%. So is that legal? The doctor's office calls and says, your patient was discharged, ready for a prosthesis, can you go to their home? And many doctors routinely request home visits for prosthetics. Because most prosthetic companies are like, oh yeah, we do home visits for prosthetics. So that's where my confusion is with established patient and new patients and home visits also.
This is Miguel Mojica. If we want to define established patient, we can. I think there's a definition area. But I think what Yvonne was saying, and that's the way I would see an established patient to me, is that you've got an order, you've got a chart, you've got some information at your main office, and then you go to see them. I don't think it's meaning you've seen the patient and they've come to your office and they've been established and then you go there. So, but we may want to, I don't know if there's another term we could use instead of established patient, or define what an established patient is.
What we were trying to do is make it clear that when you practice in a facility, you sometimes go out of it.
Correct.
And that
Sure.
wasn't in the rules before.
Right.
And
it
we
was very
didn't want it
confusing.
to appear inappropriate, because it is a normal part of practice.
Randy Duncan, and I think item number 3 covers anything that's not covered by number 2.
I agree.
If it's a, say, new patient that happens to be a child with some sort of, immune deficiency that can't leave the home, that there's a appropriate and commensurate reason for us to go into the facility, I'd say that 3 certainly covers that.
But do you think it's
But-
clear or unclear as to
An
whether they have
amputee
to
is
have
not-
an in-site
An
visit?
amputee wouldn't meet this requirement.
It could be considered a physical limitation. In number 3.
Okay.
If the amputee states, I can't come see you because I'm an amputee, I have a wheelchair, whatever, that
Okay.
would work.
Some people
And right
don't
now,
have
it
a
doesn't
card.
say there has to
I
be
just-
an in-house, in-site visit first. It doesn't actually say that, but
And that makes sense to me now.
you know-
But I'm just
Yeah.
saying, if I had read this and didn't have this explanation, I would be
Established those
confused.
you are.
So I don't know if we can come up with different wording. I'm okay with it, but I just think it,
And again, Mary Winston, this does go out for public comment, so other people in the field, if they have the same concerns, they can definitely come back
Good.
and let us know.
Ask a question.
Yes.
thank you.
Okay.
Do we need to? Could we just take it out and have everything in 3 become new 2? Would that be adequate?
Seems like it would be.
Everything in 3 becomes 2. Combine the 2?
We'll just take out 2.
Yeah, 3 covers it. Because, established patient is something routinely said in my office. I don't want to throw more confusion. Is that an established or a new patient? And everyone in my office knows what that is. There's a difference between established and new. Even though we have a prescription, still a new patient. Till we've actually physically seen them in the office the first time, and now it's established. That's our interpretation. I'm okay with this. I don't want to confuse things too much.
Yeah, I think we leave it as is. And then,
Okay?
like Mary mentioned, once we put it out there, if we do get a lot of questions regarding that, then definitely we would potentially switch it.
Okay.
Catherine Mize, Laura, can I ask a question about something that's not highlighted here?
Sure.
Okay, so I've had this brought up to me by practitioners on the fees, if we're finished with that discussion we were just having?
Yes.
Okay, on the fees, if you are licensed in one discipline, let's say you're a LO, and then you're also a assistant in the other one, when you combine those two fees, your total fee is $500 for your licensing. So that, you're a licensed orthotist and you're an assistant prosthetist. You're gonna pay $500, whereas if you're a full licensed orthotist prosthetist, you're gonna pay $400. So I don't know if that would, this person or these people view this as a overcharge, I guess you would say. And I didn't know if that was a situation that we could remedy or would want to.
We have the renewal price break, so you're just talking about initial.
So that would just be the initial charge, okay?
If you look at 19 on page 29,
Okay, processor's assistant.
Oh, cool.
Okay. I guess I had not seen that. Thank you.
So
Never seen that either.
the B then, where it says schedule of fees, is to get it started, you would pay that amount, and then renewal then drops, okay.
Okay, so the next section after fees with changes is the professional standards, basis for disciplinary action. I guess, well, the main thing you'll notice here is it's removing the civil penalty, and that all of the enforcement provisions basically were removed from the statute by HB 4007, and one of those enforcement provisions is a civil penalty. I doubt that it was ever used, and it's still in Chapter 51, so if we really wanted to use a civil penalty, we still have that option because it's in 51. For most of these programs that are moving in that have penalty and enforcement provisions in their Enabling Act, most of those are being removed, and so it just defaults to the Chapter 51 TDLR enforcement provisions. So it's not really anything to be concerned about. We still have the enforcement authority. It's just there in the universal statute and rules. And this added a violation for failing to report a known violation of the Act or this chapter to the department in 28. And the rest is really cleanup and no real substantive change. We've decided to use the term order instead of prescription, so prescription where it appears is changing to order. I don't think there's anything there that is too controversial. If you have any questions.
So we need to have a motion to propose these changes? Is that the next step?
Randy Duncan, I make a motion to release the changes for public comment.
Okay. Now, the only thing we aren't clear on is whether to change that requirement for the posting of the practitioner licenses to where the public sees them or where only the patients need to see them. if you want to make a decision, just go ahead and propose them as where they're available for inspection by the public.
So I would make a motion that facility accreditation license be readily available to the public, and individual practitioner licenses are made available to patients within the facility in a common area, such as a hallway.
Okay, well,
Is that,
Mary Winston, TDLR, if we could, I would like to request just a 5-minute break, and then we can get back to that, if that's okay, Mr. Mohican?
Yeah, that's fine.
Okay.
Let's go ahead and take a 5-minute break.
that was you was asking?
Hold on. Back to order again. It is 12:07.
Mary Winston, TDLR. I wanted to start the meeting by saying we had, and I'm going to thank Tamla for this because she's running this without a microphone. We had two motions at the close just before the break that right now have died in time, and so we're going to present some more information regarding those motions, and we'll start afresh with new motions just to clean the record.
Okay.
So, and Laura will now finish that up for us.
Okay, I'm Laura Pefferly with the General Counsel's Office, and we were talking about in section 114.29, accreditation of facilities, about the posting of the license certificates of the practitioners in the facility. And currently, the rule says an accredited facility must display the license certificates of its practitioners in a prominent location in the facility where they are available for inspection by the public. And the change that was advocated by the board was that be changed to available for inspection by patients, so that it didn't require all the certificates to be posted in the front area where the public could come in and see them without having to ask to be escorted to see them, or, you know, that they would all have to be up front. And there could be a lot of certificates to post. The facility certificate is required to be posted where it can be seen by the public, which would mean the public walking in off the street can see it. Because this has been discussed and debated a lot, I checked and with the department, and we think that we have some wording that might satisfy this requirement and this inconvenience of having to post the certificates in the front area, basically. And so we'd like to suggest that you consider some alternative language here to change this to say an accredited facility must display the license certificates of its practitioners in a prominent location in the facility where they are available for inspection by patients, and by the public upon request. And this would mean that they could be posted in a hallway or a room, but if the public wants to see them, then the facility will have to show them to them. So I think that might be a happy medium that would work if you're agreeable to that language.
Yes.
I'm good with that.
Yep, I think we're all good with it.
Okay. And of course, this, like all the other changes, is going out for public comment. So if there's any comment about that, we can address that. And so I think we've talked about all the changes. If you have any other questions before you make your decision to vote, I'd be happy to answer them.
Randy Duncan, I make a motion to accept the changes as written, including the new change to the public posting for public comment.
I second the motion.
All in favor? Aye. All against? So moved. Laura, thank you very much.
Thank you.
And Yvonne, I'm
you're a
sorry.
huge help. Thank you.
One of these days, I want to say nay, just
for
to
fun?
break up the, just to break up the monotony.
Troublemaker.
So we're now on item F, number 1, report from Standard of Care Work Group. Do we have anything to report from there? Or was this only?
That was it.
That was
That
it,
was
so
it.
it's all
Yeah,
at once, okay.
that's it. You've done
The
that.
proposed rule, okay. So we're now moving to item G, recommendations for agenda items for the next board meeting. Anybody have any items that we want to put forth today?
Mary Winston, TDLR, we have Leonard coming up with a little information, supplemental from his report. He's going to handle that right now, and
All right.
then we can move forward, if that's okay.
Leonard Rivas Licensing Division. There was a question about the number of uniquely qualified applications that we've processed. And so from January 1st, 2017 through today, we've had 9 uniquely qualified applications total.
Okay.
You-
From January 1st of 17.
17 through today.
And that's
9.
one more than I remembered. I remember the number 8, so I knew it was pretty low.
Thank you.
Okay. Any other questions about UQ?
Of those 9 that applied, how many were
I knew
stamped?
that was coming. So I have it here, though.
That's coming.
So 2 are in process, 6 have been approved, and 1 withdrew.
Thank you.
You're welcome. Thanks.
And with that, Mary Winston, we have gone over the rules to be proposed for public, to be out there for public comment. So for the next meeting, after this public comment period, Laura will come back with all the comments that she got and before the full board, and we will discuss that, whether or not to move this forward at that time to the commission for a final vote.
Thanks,
So that's
Mary.
one thing. That's a big thing. And as always, if there are other items that come up before that time, just contact advisory.boards and we'll get them on the agenda.
So no other items need to be added. So we'll move to the next section, discussion of date, or item, discussion of date, time, and location of the next board meeting.
Chairman, we have 2 dates that would give us, keep us on our schedule. We have 10 a.m. Friday, April 27th available. And we also have Friday, May 4th, but we would have to do it at 9 a.m. Previous meeting.
I prefer the 10 a.m. ones than the 9 a.m.
I concur. So everybody good with April 27th at 10 a.m.?
I believe that I'm out, but I'm just one. I think that's a weekend I have planned to be on vacation. But it's just me.
So May 20, or on May 4th, are you available at 9?
I'm out.
Okay.
I think I'm out too. I think that's when my nephew's white coat ceremony is.
Oh, you need to be there for that. Yeah. So let's stick with April 27th then, for now.
I may be out the 20th, I don't remember, so.
Okay. So April 27th, I think,
At 10 a.m.
at 10 a.m. I
Thank you.
think is what we'll.
And that gives us enough time for public comment?
And public comment closes, I think, the 16th of April. And so that will give Laura time to gather all the comments, get a report back to you for the next meeting. And handle all the other programs that she is responsible for.
All right. Next item is adjournment. Do I hear a motion to adjourn?
Motion to,
Go ahead, you go.
motion to adjourn.
Have a second?
I'll second it.
All in favor? Aye. All against? So moved.